In our earlier videos, we explained what MIG is and how it restricts the amount of money available to accident victims for medical treatment, that being $3,500, and how with most people that amount will prove to be insufficient to permit adequate recovery. We also learned that the $3,500 in coverage is in reality not even $3,500, since that includes the cost of assessment, examinations, and form preparation. And these activities can eat up a good chunk of that $3,500 limit. We also reviewed the complex legal concept of threshold, what defines the compensation that accident victims can expect for the pain and suffering caused by their injuries. And we explained why it is difficult for most accident victims to successfully sue for pain and suffering compensation. And yet our law firm is settling cases for car accident victims frequently and doing just that, obtaining compensation for pain and suffering notwithstanding the challenges caused by the threshold law.
So just how do we do it? Well, we have a unique solution at Ashley Gnyś, but we would need to review your case to see if you qualify. First of all, if the car accident was your fault, we can't help you. If you were not at fault, then we can help you in the following circumstances. 1. The single easiest way to prove that your injuries meet the threshold test is to show how the impairments from your injuries have caused you to miss time from work, or alternatively, you return to work, but you are now working reduced hours or engaging in modified employment. 2. If you were not working at the time of the accident, we may also be able to help you if you were a student and your injuries now prevent you from attending school or pursuing your career path. 3. You were not in the workforce, but your injuries have prevented you from doing aspects of your housekeeping and home maintenance tasks. Perhaps you've hired help, or you have family members or friends that are doing housekeeping and home maintenance tasks for you that you routinely did before your car accident.
If our personal injury unit accepts you as a client, we may be able to secure for you what is called a litigation loan, which can be used to fund your additional medical treatment. The loan comes from a lending agency that specializes in giving people like you involved in a personal injury lawsuit monies to fund their medical treatment. The loan is paid back from the settlement that we are able to achieve for you when your case is settled. No payments are made toward the lender by you until your case either partially or finally is settled. The funding of your additional treatment will also serve the additional purpose of gathering the medical reports from your physicians to prove that your injuries meet threshold. This also permits you to have legal representation, which will be vital if it is to be proven that your injuries meet the threshold, since we as experts know how to assemble the necessary evidence. If your injuries have not been treated under the Minor Injury Guideline, and you have available to you $50,000 in medical rehabilitation coverage, this is great evidence that your injuries are not minor, and that you will probably stand a better chance of proving that they meet threshold. If that is your situation, then give us a phone call and we will discuss your case in more detail. In our next video segment, we will look at ways we might be able to help get you out of the Minor Injury Guideline system and get your insurance company to increase your funding from $3,500 all the way up to $50,000. Thank you for your attention, and I hope this information is helpful to you.